Prop 36, the old Prop 36, and PC 1000 are two different drug treatment programs which are available to defendants who are charged with crimes of simple possession, being under the influence, or possession of paraphernalia related to drug use, as opposed to drug trafficking types of crimes. PC 1000 is known as Diversion, PC 1000, or Deferred Entry of Judgment, also known as DEJ. So there are a lot of different names for this particular drug program. Prop 36, which is found under Penal Code 1210.1, is usually known just as Prop 36 treatment. And the two are vastly different ways of addressing the drug treatment approach to punishment of low-level drug offenders or simple possession drug offenders. PC 1000 diversion, it does require a guilty plea, which is similar to Prop 36. However, with PC 1000, so long as you complete the program, you are never sentenced, and the prosecution of the crime is never truly complete. What happens is you enter a plea of guilty, and then proceedings are suspended in the criminal case. You attend about a 4-month drug treatment program, and then there's a subsequent period of approximately 12 to 14 months of monitoring, very low-level monitoring, not by probation, just by the court, of the offender. At the end of that period, the plea is withdrawn and the case is dismissed, and it's as if it never happened. With Prop 36, on the other hand, you enter a plea of guilty, and then the offender is sentenced. So you are actually sentenced and put on probation, and it's formal probation, which is usually called felony probation, whether or not the underlying offense was a misdemeanor or a felony. There's then an intensive drug treatment program, which is closely monitored both by the court and by probation. And they monitor you for probation violations, and you're subject to other probation terms. Only if you are successful in your drug treatment program, and if you otherwise abide by the terms of probation, the case is dismissed at the end of about 18 months if everything goes as planned, similar to the PC 1000. But the dismissal is not nearly as complete in removing it from your record or expunging the prosecution from your record as under the PC 1000 system. Under many circumstances, you still must disclose the arrest and the conviction, although you can say that it has been dismissed pursuant to Prop 36. PC 1000 is a much more effective way of removing something from your record, and it basically leaves no footprint behind for people to follow. PC 1000 is the clear winner in terms of expungement and impacts on your life, although they are both beneficial programs to low-level drug offenders. As a former prosecutor, one thing to keep in mind is that the prosecutor is the one that determines whether or not the defendant or the crime itself is eligible. And it's laid out quite clearly exactly who is eligible and what sort of crimes are eligible. There's a little wiggle room with eligibility determinations for Prop 36, but it's very clearly laid out in the code for PC 1000. It is very important when you're approaching a prosecutor that the client be framed correctly as a good candidate for drug treatment or an excellent example of a future citizen, someone who can atone for their mistake. That is one reason why it is vital that you have an attorney that understands the eligibility requirements and the eligibility guidelines for each of these programs. Because if you are dealing with a DA or a prosecutor that doesn't truly understand or is unwilling to see the error of their ways, you as the defendant could easily be facing criminal punishment until and unless the appellate court reverses the DA's erroneous decision.